Okay, well, good afternoon. What great energy. You can feel it in the room already. You guys did some really excellent submissions. I got to see a good portion of them. Amazing, amazing. And also the presentations and the arguments and then the final agreements. Amazing job. I look back, I'm getting a little long in the tooth, a little older, and so you always hear about when an older person went to school, they walked uphill both ways. Everything was harder, and it was better then. But I got to say, I don't think so. I mean, I did it in 2000, about 10 years ago, this moot, and I think we did well, hey, Marty? And Christy and Miranda's gone. But the level that you guys are at is phenomenal. So what we're going to do here today is we're going to kick it off in a moment with the tables coming up. Everyone come up, even if you just have a presenter or two presenting, we want to see you. It'd be great if the facilitator came up so we can acknowledge all the great work that the groups did. That's how we'd like to proceed. But what we're going to do first is I'm going to invite up Jesse McCormick, and he's going to give some observations about the Kawaskimhon Moot and the level of submissions and presentations. So Jesse, if you can come up, that'd be fantastic.
Bonjour, Kanoya, Jesse McCormick, Indigenous, Deshkan Zibing, Donjaba. The immense pleasure it is to stand here before you and to acknowledge the opportunity to work, play, and participate in these dialogues here in the unceded and traditional territory of the Secwépemc people, Secwépemc Gulu. I live here, I live down the street, but to share in the warmth of this institution, the people have helped to make all of this come together, and the opportunity to observe and to learn from the students as a facilitator was of so much value to me individually and I think as a collective. And these are the types of organization and gatherings that launch a career, that can bring people together. You will see people you met here as you move forward in your careers, and that's of great value to you. We did a around the circle discussion of things learned at the end of it, and it all came back to people. It came back to the idea that how you approach this work, how you carry yourself, the tone and tenor that you bring, the willingness to understand and learn from others and to see through the eyes of the other parties in order to come to an agreement and share a view that can be presented on a consensus basis is the real power of this moot. Unlike the adversarial moots where you have to defeat your opponent, in this case you're working to hold your opponent up, achieve their ends while achieving your own. And that is a powerful tool for you as you move forward in your legal careers. And to do that informed by knowledge of Indigenous law, knowledge of Aboriginal law, guiding principles that each of us bring from our own respective histories and the learnings and teachings that come from engaging these problems, understanding the power dynamics and the impacts that they're having on real people are immensely important tools to you as you move forward in your legal careers. So let me be the first to congratulate you on the amazing work, to thank everyone who helped in organizing this, and to offer you my profound appreciation for the chance to be part of it. Chimigwech, thank you very much.
All right, thank you for those kind words, Jesse. Let's go with table one. Why not start in order? So table one, come on up. It'd be great if your facilitator came up. Like I said, if you only have one person presenting, that's fine, but we'd like to see the whole table come up, okay? And facilitator.
Okay.
Oh yeah, for sure.
If you want me to point to something.
Yeah, for sure. Oh wow, this is a really big room when everyone's looking down on me. But I just want to thank everyone today for giving us an opportunity to speak a little bit about, here, let me just get this. I'm a really tall person, so. So we were table one, and we decided that we came to an understanding in creating a letter of understanding that led to future negotiations that would lead to a consent-based agreement. Myself, I, and my partners, Jennifer and Ali, that's attending virtually, we represented SSN, and the main focus that we wanted to get at was incorporating an agreement that would respect Aboriginal rights and title, and also incorporate free, prior, and informed consent in future negotiations in getting that consent-based agreement. And so a little bit that we talked about was it led to a vast majority of concepts that were from the community, but also respected the other parties that were there. That we talked about funding, dispute resolution, and many things that we took away, and we just had a great collaborative group. And I will call upon the provincial crown and talking a little bit about incorporating the laws of each nation and that sort of thing.
Hi everyone. Rob and I were assigned the enviable role of Crown, Federal Crown. So we wanted to somehow come in and not make it combative, because that's not the nature of the moot, which is a little bit of a challenge when you're assigned the Federal Crown. So we tried to sort of be the ideal crown. I know that those words are pretty far apart in terms of what's in your brain and our brain as well. But what we tried to do is take the honor of the crown seriously. So we tried to front as much as possible the deep wrongs, the ongoing wrongs, the fact that the pipeline is essentially moving forward, and use that to crack open a window of crown responsibility in which we could actually have productive conversations. So that was sort of our framing device, and sort of hopefully set the tone for good vibes in the room a little bit in terms of being a little bit productive and creative. And just personally, I want to say thank you for the chance to learn, to create relationships, and thank you.
And then me and Connor were representing Government of BC, and we found it really important to braid in the Secwépemc law. So we were guided by the story of Secwépemc, porcupine, and coyote and fox, liberation of the Chinook winds, and extracted laws from there in order to guide our framework for our agreement. So you can see an example here under 15A and B. We have some laws written out that set out how the section would go. We found it important to braid international, state, and Secwépemc law. We were also very, very lucky to have Charlotte Rose help us and guide us with her vast, vast knowledge of the nation and the laws within it to guide us.
Do other parties would like to speak?
No. I think it's like 5 minutes, right?
Yeah. We just want to say thank you, and a special thanks to Charlotte, who just was phenomenal in helping us guide, laying out the foundation for this MOU, or the letter of understanding. As it'll lead to the overall goal of coming together with great consensus. So we appreciate that. Thank you.
Okay, I would now like to invite Table 2 for the presentation. Table 2.
Okay. Hi, I'm Shannon. I represented SSN at Table 2 with Henry and Eric. We just wanted to start off by doing a shout out to our facilitator, Judge Thomas. Her experience really helped guide us through some kind of crunchy conversations, and I know everyone really appreciated having her at our table. And we also want to do kind of a thank you for all the parties that were at our table, because even though it is meant to be a negotiation, we know there are parts where, there is going to be some conflict. So Sage and John representing FNA, Blueberry River represented by Jonah, Jackie, and Laura, NRC represented by Kate and Ryan, Cernak by Taylor and Kayla, and the province by Megan and Katrina. And we're going to go through the agreement that we came to, which is actually called the Porcupine Agreement. And so there are sort of main areas where the area in question, an environmental assessment process, land management, community benefits, and then Cernak is also going to talk about some learning moments.
Yeah, so thank you. Yeah, so I mean, SSN was putting in a ton of work, and all the parties were, and it was really fantastic. So as the FNA, we came at it from an environmental perspective, right? The environmental impact assessment. It was important to share our clients' perspective on natural resource extraction in Northern Ontario, and I'm sure that many of you are aware of of what's going on up there, and so an important perspective for us to bring forward was how Indigenous-led environmental impact assessments could be collaborative, right? So we looked at our table mates across the way, right? Blueberry River First Nation, for example, to inform and add to our understanding of what cumulative impacts looks like. We got everyone's perspectives on how we can embody the principles of FPIC and good faith effort, and having dispute mechanisms that we can fall back on to ensure that conversation is continuing and that it's productive. That was a really, really important point, and I think all the parties did a fantastic job embodying that and bringing that forward. So, yeah.
And then speaking from Blueberry River's perspective, we kind of came to the table having negotiated our own agreement that over a span of a couple of years, and we wanted to come to the table with our experience in that, but also being mindful that SSN's territory is a very different context, and they'll have different values and needs that they're trying to achieve. And ultimately, we talked a lot about land management and adapted several elements of the BRFN agreement aimed at protecting and healing the land, but also modified based on SSN specific needs. So 3 kind of key elements that we negotiated. The first is to split the territory into differently protected areas based on their importance to SSN, and certain areas we designated as no-go zones in that they're not going to have any new development on them and existing development will be winding down. That was something that we were able to come to agreement on with SSN, the province, and the federal government. And then in conjunction with that, we built a restoration bond with initial contributions from BC and Canada and contributions to be made by industry proponents as well. And then finally, the creation of a preservation society to do ongoing monitoring of environmental health and project impacts in SSN territory. And again, this is something that I think we were able to build a lot of consensus on, as everyone was kind of mindful of the importance of protecting the environment and healing the land while also still making provisions to allow economic development to go forward.
So our next sort of frame that we agreed upon was community benefits. This was about the least contentious area in our entire negotiation. It was all pretty straightforward, very collaborative between all the parties, and there was a general agreement. The community benefits section set out a variety of requirements that would be a part of future impact benefit agreements or any contracts for parties looking to undertake projects in SSN territory. So very broadly, SSN came to the table with a lot of proposals already set out, which many of them were agreed to. So we agreed on certain employment quotas, as like 35% for general workers, 25% for middle management, 15% for upper management. We agreed that any parties undertaking projects on the territory would put forward and fund employment training for both SSN and industry workers. We recognize that SSN members looking to be employed by these projects would need some support in undertaking training to fulfill their roles. So we agreed to fund that, as well as cultural training to protect members of SSN on projects on their territory, as well as to facilitate understanding between settler and transient workers and the rest of the community. We also brought forward the importance of safety training, police checks perhaps, and sexual harassment training to protect Indigenous women, girls, and Two-Spirit individuals on the territory, as projects tend to have harmful effects in that regard. We also established a community development fund to give back to the community and create that reciprocal relationship between project proponents and the community. Those funds would come from project proponents, and they would be a set range dependent on project profit and other factors. We also agreed that revenue sharing would be something that it would be important to any future agreement, and that would be negotiated based on the specific project.
Hello, everyone. So I am representing my co-counsel and I for the Ministry of Environment and Climate Change Strategy, and just speaking a little bit more on the aspect of how we negotiated a tax splitting scheme for provincial government projects, considering provincial government land. And so we did negotiate that to 20%. And although CERNAC was not able to commit to the same thing, we were able to practice our negotiation skills. Yeah, just so as the provincial government, it definitely was it was a journey representing a party that is trying to have a more progressive outlook. But also balancing all government priorities. So we do acknowledge the tough role that CERNAC had to play, and I just wanted to give a shout out to them because they really did, have a challenging position at times, but with great humility and positivity, they did just put their best foot forward. And so I don't know if there's anything else that they want to add about their experience with the tax splitting scheme, but I think I'll just turn the floor to them to share with their experience.
Thank you so much, first of all. So we were CERNAC, if you got that, but we wanted to quickly thank everyone for this event, and also shout out to our coach, Dave, and all the coaches who are here with us today, because we wouldn't have been able to do this without our coach, so we just wanted to say that off the bat. And then I think just for learning experiences for us, one of the big ones is we were assigned CERNAC, which isn't something that necessarily aligns with our personal values, but it was a learning experience to have to navigate how to represent that client, while not necessarily personally agreeing with some of the interests that they had. So overall, that was one big learning experience for us. And then coming out of the moot, I think Judge Thomas said being hard on the position but not the people was something that stuck with all of us, because there was some contention at times, but we could step back from the moot and then, interact in the hallways and still be friends at the end of the day, because these are people that we're gonna work with. And then one other thing that was really important, I think, was developing a dispute resolution process. So we knew that going forward, if we didn't agree, we actually had an agreed upon process on how to deal with that, which made, you guys, I think, can all agree it made it easier to go forward with the negotiation. And there was one more point I was gonna make, if I can remember. Oh, one thing that was also a learning experience that we talked about was like language, because sometimes we'd be disagreeing and then realize we were saying the same thing in different ways. So just taking the time to listen and really hear your other team's interests was something that helped us a lot, because sometimes we were actually on the same page, but using different words. So I think that's everything from us. But thanks again, everyone, and thanks to all of you guys.
Yeah, thanks, guys.
I was like, I'm here for moral support.
All right, group three. Group three.
Testing. Assalamu alaikum, everybody. Peace be upon you all. This is my traditional way of introducing myself and everybody here. We would like to acknowledge that we are on the traditional territories of emlúps, Secwépemc lands, and in doing so, we appreciate the ability to be here to negotiate. We would also like to thank all of our stakeholders. Over the last 2 days, we have been engaging rigorously in meaningful negotiations with each party and each stakeholder to develop the best governance framework possible. We also want to thank our facilitator, Marty McNaughton, for her incredible work in guiding us during these negotiations. As a result of the deviation going through with SSN's approval, the opening of the MBA has resulted in an opportunity to enhance the existing agreement with TMX, with pressure from both federal crowns and the National Resource Coalition. In particular, the new government will include the existing agreement will include a special equity arrangement where SSN will have a special class share, which would include a veto over certain decisions. Through this process, we have created a new governance framework as well, which is contingent on, the MBA is contingent on a broader governance framework for decisions moving forward. Just pass it on to Brendan to sort of talk about the inspiration.
Hi everyone, so Mohammed and I were counsel for SSN, and we came to the negotiations today with 3 aims. One, we wanted the negotiations to be framed by the Haida Gwaii Management Council. So in this agreement, we've employed joint decision making where we can. Another inspiration we had was Treaty 9's claim that's going in Ontario right now, arguing that Treaty 9 meant a guarantee to continued way of life. So we made this guarantee one of the hearts of our agreement. Another one was ensuring SSN controlled the evidence that was central in decision making. So we really made Indigenous-led impact assessments another heart of this agreement. I'm going to pass it on to our 2 colleagues to talk more about the agreement.
Hi everyone, my name is Zach, and myself, along with my friend Nick, represented the FNA. And I'm quickly handing it back to my other friend, Mohammed.
Sorry, I'm just going to go over quickly the guiding principles for this agreement. It is a tripartite agreement with the province of British Columbia and the federal government. And it will be based on a nation-to-nation relationship that's based on mutual respect, reciprocal accountability, and stewardship. One of the more important principles is recognizing SSN's inherent jurisdiction over Area F as submitted by SSN, and that this agreement and any action arising from it does not transfer legal jurisdiction to the other parties in this agreement. SSN shall have final say over issues that impact only Area F in ensuring the cultural practices of SSN and that ensure the continued way of life of SSN, including but not limited to wildlife, spawning areas, and other areas as dedicated by the Joint Management Agreement. Any issues impacting lands outside of Area F remain under joint decision-making structures. Importantly, the framework is to be interpreted through UNDRIP and in particular through Section 6 and 7 of DRIPA for the province of British Columbia. I'll go and pass it on forward to my teammates.
Hello again. With respect to decision-making structure, decision-making authority will be negotiated at a later date. However, the agreed-upon categories include SSN-led decision-making, joint decision-making and co-management, BC-led decision-making, as well as Canada-led decision-making over issues of national interest and security. With respect to the decision-making body, we believe that 5 or 9 decision-makers, depending on the complexity, will be best suited. If a consensus is not reached, an independent chairperson makes the final decision. If an independent chairperson cannot be agreed upon, each party will select their suggestion for an independent chairperson, and those 2 individuals will then appoint a single independent chairperson. The 2 underlying committees present information to ultimately be decided by decision-making bodies. With respect to the Cultural Committee, this would cover cultural practices to help ensure the decisions considering SSN interests. Furthermore, SSN is to determine the format of the decision-making structure, led by an SSN-only committee. The SSN committee should also be the only body to decide the cultural competency training required through the duration of the approved project, including safe working conditions, and can also mandate cultural competency training as part of the decision-making body assessment process, following both reciprocal and cultural working group protocols. In terms of the Impact Assessment Committee, Indigenous-led the SSN-only committee is dedicated to following a walking with two legs approach, meaning the integration of both traditional ecological knowledge as well as science. The existing provincial Crown and Impact Assessment, as well as the Environmental Assessment Acts, also have the ability to support an Indigenous-led assessment process. For example, the SSN environmental assessments shall substitute Environmental Assessment Act assessments under BC jurisdiction. A settled agreement shall not be displaced by the committee, and if the SSN is leading an impact assessment, they will meet the minimum standards of the applicable Environmental and Impact Assessment Act. With respect to Crown conversion, the province acknowledges and agrees that no further conversions from Crown land to fee simple private land or to fee simple agricultural use will occur without the consent of the SSN, and, as may be necessary, support from any Indigenous groups with interests in the affected portion of the agreement area. CERNAC also understands that most land is provincial Crown land and is willing to work with the SSN in matters as such. For example, they may federalize fee simple lands around PIPSEL as an option if this is a concern. In terms of industry considerations, Impact Assessment Committee shall have at least one mutually agreed upon industry member on the assessment panel. In the event of a disagreement, one expert will be chosen by each party to decide on the final expert participant. Participation in resource management planning process will look something like the parties shall engage with all relevant tenure holders and proponents to design plans for coordinated restoration and development activities within the agreed upon area. This agreement is also dedicated to a commitment to reflect similar expeditious timelines as agreed to in the BRFN agreement. There's also a commitment to negotiate timelines in the future and include other potentially impacted Indigenous groups in the planning process where there may be impacts to their rights and/or title. In terms of reciprocal cultural working groups, the SSN is to work with BC as well as Canada to increase cultural competency through SSN-led training programs. The option to include industry parties, such as reciprocal relationships, can also include industry training Indigenous groups on technical aspects of the projects and future projects. With respect to funding, the funding is derived from BC and Canada's ongoing commitment to meaningfully consult with First Nations and communities. This degree of training would be based on the scope of the project and the impact to SSN rights. This would also include required timelines and the option to consent to shorter timelines. The Cultural Committee will also engage with the Crown and industry to determine the degree of reciprocal training required. Furthermore, the process begins when the project application is submitted. I am now handing this over to my friend Nick.
Thank you, Zach. So I'm going to begin by talking about our dispute resolution model that we came up with. And with this, we are using it as a way to recognize the aspects of SSN rights. The parties agree to a joint tribunal process that includes both Crown and SSN legal protocols. Our dispute resolution in relation to this agreement will have a similar dispute resolution process to the New Zealand Waitangi Tribunal, which is a bicultural and bilingual mediation process, which is broken down into two methods. The first method, if SSN believes that all issues have not been addressed, then first, equal SSN and Crown representatives, as well as a third-party facilitator, meet to try and resolve. If there is no unanimous agreement, there will be a written resolution. If no unanimous agreement, the SSN lead and Crown Commissioner will then meet to resolve. If there is, at that point, still no agreement, we can be brought to a tribunal equivalent to the Waitangi Tribunal. And this leads into our second method, in which the party bringing the dispute will provide a written notice to the other parties, and then they will meet within 10 days to go through collaborative negotiations. If these negotiations fail, the issue shall be referred to mediation, providing a non-binding recommendation. This recommendation is subject to collaborative negotiations. If this format in mediation is unsuccessful, dispute shall be brought to a tribunal equivalent to the Waitangi Tribunal again. Moving on to renewals of potential agreements, we have installed a protection clause which provides 10 years of protection against termination. And once that protection period is passed, the involved parties can meet to renew the following aspects of the agreement in a consent-based process, which is in 3 categories: the scope of the agreement, the rights involved, and the compositional structure of boards, committees, and working groups. And that leads into amendments and terminations. If any of the parties to this agreement intend to effect what they believe is a material change, or they believe the actions of a party have amounted to a material change, they shall bring their concerns to the decision-making body as described above, and that body shall decide if a material change has occurred and specify what, if any, modifications needed in the agreement. We've also defined what constitutes a material change, which is broken down to about 6 points. The first one being that decisions made by joint decision-making bodies that are not followed, a change in crowd representation, rights in area, funding, processing committees, and also noting that this is not an exhaustive list and can be expanded on at any point. And should a dispute arise in decision-making body and is not resolved, that a material change has occurred in the dispute resolution process shall be engaged. Nothing in this section precludes any party from withdrawing from the agreement with notice as appropriate to respect the rights and welfare of other parties as described in individual agreements, or voids or violates the limitation clause above. Termination can be unilaterally triggered after the protection period where there is a material change that cannot be resolved through good faith negotiations with the involved parties. Termination of the agreement will trigger mandatory negotiations for a comprehensive land agreement, and approved activities in SSN territory will continue to be subject to the agreed conditions if the agreement is terminated. And then just to wrap things up, I would just like to extend my thanks to all my colleagues. We really had a great time, and it was great to be with so many people who are so open-minded, willing to speak, and it's just something that I will look back on very fondly for the future. Thank you.
Yeah, thank you.
You like that?
Report.
He just took it.
All right, so I'm going to speak first on behalf of Table 4. We were missing the province from our table, but Jesse kindly reached out to confirm with the province that they were in agreement with the agreement we reached at the end of the discussions. I was representing the SSN. My name's Megan, alongside my colleagues Clara and Chanel. Nicola and Richard were representing the FNAO. Alicia and Hannah were representing the NRC. We had Sabrina, Cassandra, and Jeremiah representing the BRFN. And then we had Abigail and Anisha representing CERNAC at our table. And so to begin our discussions, we recognized that there was a theme of balance running through all of the position papers that were submitted at our table. And in our early discussions around what that meant to achieve balance, we came to a point of recognizing how the overarching umbrella of federal and provincial laws that we were discussing under necessarily creates an imbalance from a starting point. And so with that in mind, in designing our agreement, we strove to create as much space for the SSN to administer their laws, to retain their cultural practices, to have their voice be heard distinctly and uniquely as much as possible. And now I'll invite Anisha to put some more details to what that ended up looking like.
So thank you everyone for being here. I will be going over the agreement that we came to. So we also had a consensus on CER's decision regarding a deviation, so I will also speak on that as well. But I'll first go through the agreement, which is forward-looking. In terms of the PIPSL area, which was private fee simple land, we agreed on a conservation covenant be registered to protect and reflect SSN's traditional and cultural access and heritage, with an accompanying co-management plan between SSN, Canada, and BC, managed by joint committees and guided by FPIC and UNDRIP principles. Particulars of the agreement include an environmental assessment process as created by SSN, which will coincide with the federal environmental assessment, and both will work in harmony if both are triggered, and with Canada having the ability to intervene if a matter is of national importance. We also came to agreement on wildlife, with Canada maintaining jurisdiction over migratory birds and species of national importance, and such species and birds will be jointly managed and conserved with the SSN and Canada. We also came to an agreement on the application of the Charter and the Canadian Human Rights Act, which will be embedded in the agreement. And if this conflicts with SSN laws, we do have an alternative dispute resolution mechanism in place, which I will talk about now. So our alternative dispute resolution mechanism has 3 stages to it. The first being knowledge sharing and negotiation between the Joint Council and a non-party cultural facilitator to encompass SSN's values, traditions, and laws, and for example, the porcupine story. The second stage being mediated dialogue, and this will encompass having chiefs from each band at the table, along with the government representatives, and with a mutually agreed upon mediator, as well as any external parties that each party may request, for example, experts. And litigation will be the last resort upon these stages being exhausted. Next, we also have the SSN Monitoring Committee, grounded in GIS. And in terms of the CER's decision, we came to a consensus that Canada and SSN will work together to explore alternative options and jointly submit to the CER these alternative options to minimize costs, while also meeting SSN's goals regarding a cap on land disturbance and avoidance of open trench mechanisms. Thank you.
Group 5.
Hi, everyone. Can everyone hear me well? Oh, okay. Hello? Okay. My name's Alphonsine.
And I'm Kiana Cardinal.
And we represented the province in the discussions. So the first day was a lot of, hashing out some disagreements, also looking at different interests we all had. But we decided, specifically with the province and SSN, that one of the agreements moving forward was that we would have an agreement in principle regarding a Section 7 agreement through the declaration, the provincial declaration, DRIPA. And so in order to do this and inform our agreement, we looked at other recent consent-based Section 7 agreements, specifically on the Tahltan territory. So within our agreement, we decided that under Section 7B of the Environmental Assessment Act, that SSN could exercise consent and decision-making authority in regards to their own Environmental Assessment Act as well. And specifically within the statutory provision, it makes sure that there's a consent of the Indigenous nation, and so that SSN has basically reflects the principle of FPIC in regarding prior future projects.
And the consent agreement that we came to is guided by principles that recognize and implement SSN rights, laws, and traditional knowledge, and respects their implementation in decision making. We looked at, again, recent agreements in the Tahltan territory, and our agreement in whole is guided by the walking on 2 legs principle. And we also highlighted the recognition and implementation of SSN's legal principles to harmonize the discrepancies within the provincial Environmental Assessment Act, process. We included 2 guiding SSN legal principles, which I regrettably cannot pronounce. But the first one talks about how if you disrespect the land and don't take proper care of it, the land and sky will turn on you. And then the second one refers to reciprocal accountability. Thank you.
So we represented the Government of Canada, me and Cami. We just wanted to thank our entire team for a really engaging discussion. It was contentious at times, but it never felt personal. It very much felt like everyone was, trying to figure out ways that we could work together and collaborate, and we really appreciated everybody's efforts, and especially our amazing facilitator. So thank you so much.
So SSN and the governments of British Columbia and Canada have entered into an additional agreement in principle relating to the broader territories of SSN. The purpose of this agreement is to provide the mechanisms by which the parties will work together in a collaborative manner towards a long-term and comprehensive agreement. The principles that underpin this agreement are transparency, respect, recognition of self-determination, reconciliation, and relationships through the walking on two legs approach. And now I will leave it with my friends representing SSN to detail that further.
The framework acknowledges that SSN are the stewards of Pipsel area and are the ultimate knowledge keepers of the land, and so moving forward they can designate high value or consent areas, which follows the Blueberry River First Nation Agreement. And so also the framework is modeled off of the larger Secwépemc government. And so with that, it kind of helps navigate how government-to-government decision-making can work. And what we did was we created working groups, which includes the senior officer team, a collaborative team, and a all our relations working group, which covers wildlife, fauna, and forestry. And so in the senior officials team, it's comprised of the chief and council from SSN, so both the nations that represents, CERNAC and the BC government. In the framework, we also incorporated a collaborative database for issue tracking. That way, any of these groups, when they encounter issues in their meetings or things they don't agree on, they can enter into that database. That way, moving forward, these issues are always accounted for and can be addressed. And if there's issues that aren't agreed upon, they can be looked at on a larger scale, where we would potentially have a BAGM. So our senior office team would have a meeting where members of the community or other members of the other ministry actors may come and kind of sit in the background and are there to observe, which kind of incorporates one of our main things that we talked about, which is transparency and open communication. And moving forward, I guess, actually something else I wanted to add was in our all our relations, this kind of also allows some of our ministry actors to kind of be in there as a supportive role to help with projects, which are kind of listed under our accommodation part of the agreement. And so because this is a living agreement, we wanted to account for current projects, past projects, and future projects. And so accommodations within those would be funding for job opportunities, scholarships within the industry, could be funding to support the implementation of this agreement, funding for wildlife and fauna restoration, and opportunities for contracting with SNN's business entities, and most importantly, mechanisms for SSN to identify past wrongs and develop a plan to move forward, which could even include having the government come and almost kind of partake in maybe Secwépemc laws that deal with harm, addressing harm. And so that could be with the land, it could be with the nation, and apologizing for doing these things like the pipeline modification. And yeah, does anyone else want to say anything?
Bonjour everyone. So my name is Cassandra and my partner's name is Matthew. We represented the First Nation Alliance. We came to the negotiation table through Anishinaabe diplomacy in the process called Migas Sapikan, where you hang a wampum belt on the front of your canoe as you travel. And the goal of it is to reach the negotiation safely and be able to participate in it. Once there, we proposed the proposal of the 4 directions relationship, which is built on the Secwépemc law of observation, which looks into the all directions to find laws, guidance, and knowledge. And based on this proposal, we were able to come to an agreement with the SSN First Nation, the emlúps to Secwépemc, and the Blueberry River First Nation. So it's a very exciting relationship that works to uphold the legal orders of one another and call on advice or participation from one another when dealing with the natural resource sector of Canada. Also, on a very personal note, we've come to the negotiation with a birch bark basket, which has been made from our territory. The birch bark basket itself has, maybe you want to walk around. We have a lovely showman right here. So the birch bark basket has sweetgrass around the top, or wingashk. This sweetgrass was gifted to us by a woman named Josephine Mandamin-Bun, who was a very revered elder in our territory. Yeah, round of applause for Josephine. Josephine Mandamin-Bun was a very revered elder in our territory that initiated water walks to protect waterways and also to raise awareness about the power of women and Indigenous legal orders. So we were gifted the sweetgrass from the family, her husband who's now surviving. And then the birch bark itself is made from the Fort William First Nation, or Nimikiwaju territory, and the Pelche family made it. So Helen Pelche herself, who works to uphold the legal orders of the trees. Yeah, another round of applause. So Matthew and myself have committed ourselves to upholding Indigenous legal orders, and very specifically Anishinaabe legal orders. This is our personal commitment, and we wanted to gift it to the local people of this region as a personal commitment to also uphold your legal orders. And this also aligns with the Boer Alaskan Faculty of Law's commitment to revitalizing Indigenous legal orders. So on behalf of our school, Matthew and myself, we would like to gift this basket to Christy Stewart, Judge Lyndon Thompson, and the elders, if you could please come on up. And Viola Thomas.
Waita, this is a beautiful, special honor, especially for me. Josephine Mandamin was my hero. She was a water fighter. The waters are like our teachings in Secwépemc territory. We're connected to water. We are the life givers. We're born in the womb of our mothers, our grandmothers, our ancestors that give us direction. Josephine Mandamin was a beautiful, powerful water walker who walked all the Great Lakes in Ontario. And she blessed me with a name, Nimpiwayum. And so it's so beautiful that I'm here at this moment to accept this gift in her honor, in lifting up Secwépemc laws to water. You heard at the opening comments from my relative, Ted Gofferson, that spoke to the connection of women and water. And we are reminded today, this gifting is a reminder of the sacredness of the water and the connection to our life givers, to our women, to our grandmothers, our mothers, our aunties, our sisters, and our great nieces. So I'm truly, humbled, and I'm truly blessed that I have this opportunity to receive this gift in honor of Josephine Mandamin, but also in honor of the sacredness of life and the sacredness in the work that you're going to do as Indigenous lawyers, as all lawyers who are participating in this moot court, to lift up our Indigenous legal orders, to lift up our right to be, to lift up our connection to the water and Mother Earth. Our life givers, they're connected, they're one and the same. Kukshim, all my relations.
Ooh, Steve.
For the water. For the mess. Thank you for lifting up.
Stay. Good work, everyone.
Group 6, cease.
I'll just
put it right here for you.
My name is Andrew Kawaskimhon and I'm a proud member of the Mastermind community in Quebec. And I was representing in the past 2 days the FNA. Before presenting our results, we think it's really important to thank our coaches, Eric Cardinal, Charlotte Chiquan-Wilson, Olivier Courtemanche, and Joël Perron-Thibodeau, as well as our facilitator, Wayne D. Garnons-Williams. We also want to extend our gratitude to TRU for this wonderful opportunity, which was filled for us with emotions and learnings. Well, before starting, we just want to mention that to represent often forgotten French-speaking Indigenous communities, we are going to present our conclusions in French. And now, since our agreement was between CERNAC and the SSN, I'm going to leave the representatives from both teams to come speak up. Thank you.
Right. So before keeping in French, we just wanted to highlight that we had an additional challenge due to the fact that 2 parties were missing at our table. So we didn't have either BC or the NRC, and that led to a crunchy situation. En passant, je m'appelle Dixon, je représentais la SSN avec mes collègues Jeanne et Charlotte. Donc tout d'abord, on s'est entendu pour négocier une entente de principe en vue d'un traité moderne qui serait négocié plus tard. Et la première chose sur laquelle on s'est entendu, c'est une série de principes directeurs qui seraient directement le préambule de notre entente de principe et qui servirait aussi à guider l'interprétation d'un futur traité moderne. Je vais vous lire les principes. Donc, premier principe, Pipsel est directement lié à la Stiptakul de Strout Children et aux enseignements et principes juridiques qu'elle contient. La tradition orale de la SSN constitue le fondement de son rapport aux terres et aux ressources Secwépemc. La nation emlúps de Secwépemc est Yahminme, hôtesse intendante de son territoire. La position de la SSN se fonde sur ses lois, son ordre juridique. La position de la SSN se fonde également sur Tkwem Eple, donc cette idée que les lois doivent continuer à évoluer dans le temps pour servir l'intérêt des générations futures. Le Secwépemc est le véhicule de la culture et des lois Secwépemc. Le territoire de la SSN réfère au Secwépemc et non nos seules limites de réserve. Secwépemc est un lieu de subsistance et d'intendance pour tout membre de la nation Secwépemc, indépendamment des divisions internes créées en partie par le régime de la loi sur les Indiens. Et le monde naturel forme un tout interconnecté dans lequel les humains et humaines sont coinquent dépendantes du Tmihu, le territoire. Et finalement, les Ceremonies, donc visiteurs et visiteuses, ont aussi des responsabilités sur le territoire de la SSN. Maintenant, avec mon collègue, on va vous présenter quelques highlights des choses sur lesquelles on s'est entendu au cours des 2 derniers jours. Donc d'abord, on s'est entendu sur un processus de prise de décision et de consultation conjointe, donc qui mène à une codécision par le Canada avec la SSN quant à l'autorisation de tout projet de développement sur son territoire. La première étape de ce processus est le dépôt d'un formulaire d'engagement préalable par tout promoteur, toute promotrice
pour témoigner d'une implication envers la SSN et ses intérêts et ses traditions juridiques dès le départ de tout développement. Cette étape mène ensuite à la classification de projets en vue d'une entente tripartite. Donc à la fin, toute entente réunit promoteurs, Canada et SSN.
I promise I'll speak I'll try to speak as slow as possible. J'aimerais me présenter, je m'appelle Mathieu et j'ai eu l'honneur de travailler.
Tu parles vraiment vite.
Did I just make a false promise? Okay. Je m'appelle Mathieu et j'ai eu le plaisir et l'honneur de travailler avec la formidable Ketura. Nous avons représenté le gouvernement du Canada. Et nous avons eu beaucoup d'attention de la part de nos collègues ici, puisque nous avions un chapeau très important c'est le moins qu'on puisse dire. Néanmoins, nous sommes extrêmement fiers de vous présenter aujourd'hui une entente qui incorpore la récente décision de la Cour suprême concernant la loi C-92. À l'effet notamment que nous nous sommes entendus pour négocier une loi au Parlement fédéral pour harmoniser les traditions juridiques de SSN et les lois des communautés concernées en matière sur le territoire PIPSEL, ainsi qu'en matière d'autodétermination et d'autogouvernance, toujours donc à la lumière de cette récente décision. Au niveau économique, nous avons également convenu de critères importants pour que l'expertise, les connaissances, les entreprises de SSN et des collectivités membres puissent être considérées en priorité au moment des processus d'appel d'offres qui impliquent le gouvernement du Canada. Au surplus également, en matière de protection du territoire, nous avons convenu d'un processus d'évaluation environnementale conjoint avec SSN qui, comme la plupart d'entre vous avez suggéré, et vient englober également le processus fédéral de manière à créer un dialogue entre les deux. Nous avons également convenu de l'identification, de la cartographie d'espèces, de zones d'importance significative et de l'identification d'espèces animales qui seraient susceptibles d'être concernées dans un plan territorial conjoint. En résumé, nous avons eu des discussions particulièrement aujourd'hui assez émouvantes, mais nous sommes extrêmement heureux de vous présenter aujourd'hui cette entente de principe, cette Principle Agreement, qui porte notamment sur le territoire, l'implantation toute récente du projet de loi C-92 et de la décision de la Cour suprême corollaire, et également de développement économique, tout en étant conscient que nous avons réservé quelques sujets à des négociations ultérieures qui déboucheraient sur un traité moderne. J'aimerais également remercier tous mes collègues des parties intervenantes qui ont fait des contributions significatives, et je vais maintenant laisser la parole à ma collègue Léana.
Donc bonjour à tous, je m'appelle Léana et avec Chloé on représentait la Blueberry Rivers First Nation. Puis s'il y a bien quelque chose qu'on a appris aujourd'hui, c'est que c'est extrêmement important de parler au-delà de la conclusion d'une potentielle entente, de l'importance de la signification personnelle qu'une telle simulation peut avoir pour plusieurs personnes qui sont présentes ici, et de ce que ça implique en fait pour la vision du monde des parties que nous avons représentées. Nous sommes vraiment fiers de dire qu'on a réellement fait un effort de communication et qu'on a réellement entrepris de se tendre la main et de trouver des points en fait sur lesquels on pouvait s'entendre afin de répondre aux réels intérêts des parties. Et il faut aussi dire qu'on aura appris que l'émotion, c'est pas toujours un obstacle, mais ça peut exactement servir pour un outil afin de trouver réellement des points d'entente. Donc, merci à Kawaskimhon pour cette opportunité et à Thompson Rivers University de nous avoir offert un terrain de discussion ouverte. Et on est extrêmement fiers d'avoir eu l'opportunité de représenter les universités francophones aujourd'hui. Donc, je vous dis, Secwépemc, merci.
Je voudrais faire un commentaire. Bonjour, je m'appelle Wayne Garnes-Williams, je suis le facilitateur. I have a small comment. This group worked en français with only English material. Now, ce n'est pas fair, ce n'est pas juste, et j'espère qu'à l'avenir, il y aura une transaction officielle pour la prochaine équipe francophone. Or, next year, all the materials in French only. Now I'm not getting invited back, but it's true.
Yeah, I'll run it. Let me.
I just need 1 minute.
Yeah, no problem. All right, so we've had some really fantastic examples of agreements. It was fantastic to see how everyone worked together. I know that there's some contentious debate. I heard from the French table that they were very passionate, and I said, hey, I assumed that would happen. Quebecois, they're always very passionate, so it's fantastic. I also want right now to everyone to acknowledge the coaches, right? So if they can give them a round of applause because of how much work they put in. I'm not going to steal Rob's joke from earlier, but I'll pat myself on the back too because I'm a coach. So anyway, what I want to also do is just briefly highlight and thank our sponsors, okay? So OKT, First Nations Justice Council, Stewart and Springford Lawyers, Ratcliffe LLP, First Peoples Law, CN Rail Indigenous Relations, Clio, Miller Tedderly and Company, Forward Law, Woodward and Company, RJ Tour, Terra Timber, and Dawson Truck Center. We also got to put out a big round of applause in a moment because I'm going to introduce their names, is our facilitators. They put in a lot of work and they volunteered. So we want to congratulate and thank Charlotte Rose, Judge Linda Thomas, Judge Raymond Phillips, Jesse McCormick, Wayne Guerin Williams, and Marty McNaughton. And also, I want to highlight, he's been working diligently, our photograph expert, Richie. Woo! Love you, Richie, you did a great job. So I gotta just kind of tell a quick story. I don't want to ramble up here too long about Marty. So Marty was my moot partner, okay? So I shouldn't be as a professor acknowledging this or saying this, but I think she might have carried me a little bit, okay? Just a little bit. Professor Morris is calling me out. He's like, yeah, that's true. So anyway, I think I became better at negotiations than her recently because what happened is she came to the thing and said, okay, well, I'll be a facilitator, but I got to get back to my kids and I got to fly back out before the banquet, and she's going on and on. I said, no, that doesn't work for us. We were team members. You got to be here all the way. So she comes in, I can't do it. I said, that just doesn't cut it. We were team members, the four of us, Christy Stewart, Miranda Seymour that left, and Marty, and I said, no, you gotta do it. And so I've been jabbing Austin over there, and I joke and I call him TRU Law Tom Cruise. He's a bit taller, but the thing why I do that is because he was in the Navy, he served for a long time. That's part of it, right? And he's got a little bit of a swagger, so we gotta kind of rein him in, but that's okay. So going back to Marty's like, sends me a text this morning. I need TRU Law Tom Cruise. I'm like, oh, what's that? He's gonna renegotiate my flight, and I'm staying all the way. So see, I became sharper in negotiations. So I'm gonna turn it over to Marty. She's gonna give some comments about what she saw today, and we'll go from there.
Thanks, Murray. Okay, can we also give Murray a round of applause, please? He has done so much to make sure that this happened and went smoothly, and TRU Law Tom Cruise has been running around doing all of his errands, so thank you, Austin, too. So Marie and I participated in this moot in 2013, and our question was about whether nations should be able to convert reserve land to fee simple titles, so another very difficult, very contentious question, and 11 years later, I still remember it very clearly. The various parties' interests, some discussions that we had at the table. So I think this is such a good opportunity to learn because of how intimately you get to learn the subject matter, the different competing interests. So I think Jana Promislo, who's not here now, but she was our moot coach, and I was just terrified to ask questions because every time I would ask her a question, she would send me away with about 500 pages of reading, and she would say, "Here, read this, and maybe you'll have the answer after that." So, and I'm sure some of the coaches in this room have that same tactic. So, at the time, it's maybe not the most pleasant, but I mean, 11 years later, I still remember it so well. So it really is just an incredible way to learn, and I really just want to thank the students for all of your hard work. I tried to pop into as many rooms as I could, and definitely I can tell you my room was unbelievably prepared, every single student, and the short time that I spent in the other rooms, I saw a lot of the same. So thank you, students, for all of the time and effort that you put into this. It's a lot of work, and I really just hope that this sticks with you for a very, very long time, the way that it has for me. So thank you.
I don't know what's going on, but I think I'm doing a little bit of confessional today and outing myself. So Dr. Jana Promislo, I send her out an email saying, "Hey, we'd love you to come. You meant a lot to us. You know, as you guys have realized, your coaches, how much work they put in." So we wait for her. She sends me an email back, and she says, "Murray, what I remember about that is, yeah, you put in a lot of effort, but every time I sent out another textbook, you know, you need to do more reading, I caught on that you just walked by and left it, so I'm outing myself." And then she says, "Oh, I guess I should refer to you as Professor Schulte now," right? Like a jab at me, right? And also about leaving the books behind. So I'm still learning too, okay? All right, so I want to highlight a couple things. We're going to be having the banquet at the Campus Activity Center, so it's just right next door over there. The front, which you'd walk up the stairs to, my understanding is it's locked, and you can go around just on the side, which maybe they do call the front. I call it the back, and it's open over there. And I know as law students, you guys would have figured that out, but I just wanted to highlight that. So we're going to have an excellent evening of fun and entertainment and stuff like that. We're going to have traditional dance and music. We're going to have a musician come in. We're really excited because Christy Stewart, a Kamloops member, is going to put on a presentation, right? So we're excited about that. Christy was also a moot coach this year, and she was in the Kawaskimhon, as I pointed out. And we're going to have our keynote speaker. We're really excited, Chief Justice Leonard Marchand Jr., and he's been doing a lot for us here at TRU Law. One thing I want to do to finalize, and I'm not going to out myself anymore, but I want us to give a big round of applause for the Mooters themselves. We've been talking to everyone else about everyone else, but not you guys. With no further ado, let's close this closing ceremony off, and we're going to see you at the banquet shortly. Thank you.
Good evening, everybody. It is an honor for me to say a few words at the closing of this moot. TRU Law is grateful for the opportunity we've had to host you on our beautiful campus and to make your acquaintance. What I said yesterday about our duties as law schools remain true. We have to answer the calls to action in a way that is authentic. By providing learning opportunities such as this one, we present students with fact patterns that illustrate the complexity that presents when Aboriginal law and colonial law intersect. In pedagogical terms, students are challenged to achieve higher order learning outcomes. This means that while knowledge and analysis of a legal problem remains core, the higher or perhaps highest achievable learning outcome of synthesis is achieved. Students have to draw on a variety of skills to achieve a negotiated settlement. This is indeed an outstanding learning opportunity, and again, I hope that as law schools we can infuse our set curriculum with more of these simulations. In Canada, law schools are rising to meet the challenge. By engaging young minds in these worthy endeavors, we are growing our own timber. It is an absolute honor for me as the Dean to work with a great team to host this event for the first time. I hope it will be the first of many. If ever you visit Kamloops again, look us up. We are a small city with a big heart.